So at Duke we began a number of years ago to begin publishing our student-edited journals in electronic form on our website, making them available in PDF and in HTML. HTML as a way to better, as we always talk about it, expose our faculty scholarship to wider audiences than will typically see it if it's just published in the print law reviews or even electronically in a law review. We want other people to be able to read what our faculty has done. Open access is something which tries to provide information, no matter what type it is, to a wider audience, making it freely available on the web, on the internet, electronically. It takes it outside of the usual sources where scholars are talking to their immediate peers about things and makes it available to people who otherwise wouldn't be part of that conversation or the discourse within that discipline. So open access means that people who will benefit from having scholarly information on law or on any other subject but don't have access to libraries, to databases, to print forms of that scholarship, if it's made freely available on the internet, those people will have access to that information, to the knowledge that's been created, and also will be more easily able to participate in conversation about developing that knowledge further. One of the most important parts of that is that open access and electronic publication makes these materials available not only in the U.S., not only in Western Europe, not only in what we think about as being the developed world or the North, but also in the South, in Africa, in other places where the resources at universities are not as great as they are in other parts of the world. For a long time, been a large open access movement in law to make primary sources available on the web, not only in the U.S., but in many other countries of the world. But those efforts, which have accomplished a great deal in breaking down barriers to the law for people who need to use it, but again don't have access to all of the libraries and to other expensive tools. The organizations that have done a lot to improve open access to primary source legal information have not yet been able to make as much headway with secondary source materials, with scholarship, with journal articles and things like this, which is where we've stepped in, and the idea there, I think, is that those sorts of materials are more likely to be made available, better made available perhaps by the institutions which produce them rather than by aggregators such as the groups which gather together the primary source materials and make those things available. Both are needed, both are important, and it's an appropriate thing for a law school to do, to try to make its own scholarship available on a worldwide basis. What we hope to do with the repository as we expand its power and its breadth is to include not only things that are written by faculty, but also student papers. We have any number of students at Duke who not only write for journals, but are involved in scholarship in other ways and present their papers to groups within the school and will benefit from having an avenue for publishing those as well. So we will make that kind of thing available in the repository as well, along with video and other materials that will essentially show the level of intellectual activity that takes place at Duke on an ongoing daily basis, but also makes these things more readily available than they would be otherwise.